Friends, now coming to the third part of our module. In the last part, if you may recall, we discussed causation, we discussed objective and subjective liability, which you would have to constantly keep in mind, especially the subjective liability, which I talked in the earlier part, because that becomes very, very relevant for our understanding of section 300. We also discussed the definition of culpable homicide. And friends, we also discussed the explanations. You would agree with me that the Indian Penal Code is unique in the sense that it has explanations and illustrations appended to the sections, which makes the task very easy for us to understand, to construct the language of the section. So when you look at the explanation to section 299, it's very well explained, what happens when you have skillful treatment, at what point of time human body comes into existence, and in the first part where we were dealing with bodily infirmity or disease which accelerated death, and we kind of briefly discussed that whether it is the thin skull principle of the common law or not. Now in this part we would be discussing the core offence of murder, culpable homicide amounting to murder. Now for this inquiry we would have to first go through the provisions of section 300, accept the exceptions, and then we would have to see how section 299 and 300 correspond. Because for an offence to come under the category of the highest category, that is the culpable homicide amounting to murder, it should satisfy both section 299 and 300. So we will see the corresponding linkages between the two sections. Now friends, let me take you to section 300 of the IPC, which says except in the cases hereinafter excepted. So there are 5 exceptions which are listed out, which we will not look into, grave and sudden provocation, sudden fight, consent, etc., which we will not be looking, because that gets the offence under culpable homicide not amounting to murder. Our concern is the first part. So if it comes within the exception, it goes outside the culpability zone of murder. So friends, let me take you to section 300 of the IPC. It says except in the cases hereinafter excepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death, or secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or fourthly, if the person committing the act knows that it is so eminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. So friends, having understood this section and having read through it, I just hope that when I was reading out the section for you, there were certain words on which I was emphasizing, and I was doing it very consciously. And we will come to it when we are doing the correspondence between section 299 and 300. Now I hope it is clear that first you would have to establish that it is a culpable homicide. Then you would do an inquiry under section 300, whether does it come between firstly, secondly, thirdly, fourthly, and it doesn't fall under one of the exceptions. I am reiterating it because if it falls under the exception, then it is not murder, right? So, if it falls under firstly, secondly, thirdly, fourthly, without falling in one of the exceptions, it would come under the zone of murder. Now, we would have to correspond 299 and 300, and that is the inquiry which you must do. Now, section 2, so that is why, for this inquiry, I had broken section 299 for you and in A, B, C, and 300 is already firstly, secondly, thirdly, fourthly. Now, 299A, if you see, talks about intention to cause death. Now, 299A corresponds with section 300 firstly. Now, that is a very clear-cut case. Highest form, intention. You desired it, the defendant desired it, engineered it, wanted it, wished for the consequence and it happened. So it was all designed. Indira Gandhi's assassination is perhaps the best example. He wanted it, he intended it, he engineered it, he prepared for it, he had the physical element, the fault element for it, there was contemporaneity, causal link was established, highest form of fault element, intention was there, and so there's no. So 299A corresponds with section 300A. Now come to your 299B and 302A. Now let's see what the section says. Now 299 says that B says that intention to cause such bodily injury as is likely to cause death. Now it corresponds with section 302 because it says intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. So I am harping on the word offender knows. So there's a knowledge of the offender, which is, so the second 299B and 302 is about knowledge. So these both correspond. 302 says offender knows, okay, that the bodily injury intended. Now how much knowledge can be attributed to a person? Knowledge of facts, which has to be decided on case to case by the prosecution, and knowledge of consequences, which is attributable to all persons. Okay, so you have a 299B inquiry which corresponds to 302. Now I hope you are understanding that 299 is in 3 parts. I have divided it into 3 parts. This is 4 parts. Now 303 also corresponds to 299B. Let's see how it happens. 299B, as I said, it is intention to cause such bodily injury as is likely to cause death. Thirdly says, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Now the words are very tricky. The moment you said sufficient in the ordinary course of nature to cause death, does it mean an objective liability? Does it mean that, the inquiry is very objective, because sufficient in the ordinary course of nature to cause death means an objective inquiry? Please go back and read Virsa Singh versus State of Punjab. There the answers were given that how is the inquiry to be conducted in this. So we can't lose of the subjective liability which Macaulay had advocated for the Indian Penal Code. Now Virsa Singh versus State of Punjab, inter alia, said that yes, there has to be first an inquiry that a bodily injury was there. So the first inquiry is very, very objective, that a bodily injury was there. Sufficient in the ordinary course of nature to cause death, that is again that the bodily injury which is present on the body of the victim, was it sufficient in the ordinary course of nature to cause death? Would again be a very, very objective inquiry. But then there is a subjective inquiry, because it said that the offender intended to inflict that bodily injury. So that means that it's a subjective inquiry, that it was not accidental, the injury which was inflicted was not accidental. That would have to be done. So my request to you is that you must read Virsa Singh versus State of Punjab to understand the import of 303. Now we come to the last part of 300, and that is 304th, which corresponds to section 299C, and let's see how we correspond to the two sections. Now 299C says, or with the knowledge that is likely by such act to cause death. 299C starts with the benchmark of likelihood. Now 304th says that the offender knew that the act was so eminently dangerous that in all probability would cause death, or a bodily injury which was likely to cause death. So the benchmark is likelihood in both the sections. But when it says if a person committing the act knows, 304th knows for me is aggravated knowledge. Okay? And that is how I read the section 304th. Now the second part is very important because it says without any excuse. Now you must understand this is the most important part for me for section 300, because if it comes under the exceptions of section 300, it goes out of the culpability zone. But there could be cases which doesn't fall under section 300 exceptions per se, but still there could be an excuse, which gets them out of the culpability zone of murder, and 304thly second part would come to their rescue. But these are not lawful excuses, because if they're lawful excuses, you fall under part 4 general exceptions. Now just to remind you, just to give you a sense of it, the Regia's case is very important. Please go through it. The Regia case, this woman has a quarrel with her husband, goes with the child, jumps into the well. The court brought it under 304thly second part, and she was not held liable for the murder of the child. Gyarsi Bai's case is a different case, where she has a fight with her sister-in-law, comes with 3 children, jumps into the well. The court says no, there was no excuse for her to do this kind of an act. That's open for discussion given the status of women, whether it should have been murder or not. That's a different debate altogether. But in Gyarsi Bai, the court said no, she was without an excuse. She jumped into the well and was held liable for murder. So friends, this was the corresponding inquiry between section 299 and 300 for the offence of murder. That concludes our module for culpable homicide amounting to murder. In this module, in 3 parts, I had tried to do justice to this concept by giving you not only the relevant sections which deal with it, but also the fundamental general principles which you would have to keep in mind while doing an inquiry for culpable homicide amounting to murder. And as I told you in the beginning, contemporaneity principle, causation principle, objective and subjective liability would have to be engaged with, and I feel that the courts are not very actively engaging with these concepts, and that is why case law sometimes is not very helpful to us. And as criminal law students, we must engage with this, and as I tried to show you that an inquiry under section 299 and section 300, keeping these fundamental principles of criminal responsibility in mind, are very clear and precise. If we keep these in mind, we do not have to go to the common law, and section 299 and 300 are enough and very well clearly worded, with clear illustrations and explanations appended to them, for us to decide whether the offender comes within the culpable zone, culpability of murder or not. I hope I have been able to do justice to this module. Thank you.